Exceptions to Restrictive Covenants in Employment Law, Part 2. I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. Now, this second potential exception is focusing on geographical regions that your employer has its business interests in. So you might have a restrictive covenant in a contract of employment or in a settlement agreement saying that you're prevented from working for a competitor for, let's say, 12 months after you've left your employer. But the restrictive covenant might then go on to say that this does not prevent you from working for a competitor or being a competitor in regions that your employer has no interest in whatsoever. So let's take a practical example. Let's say that you have worked in the aeronautics industry in Farnborough, and for whatever reason, you've upped sticks and you've gone to work and live in Birmingham. Now, let's say that your employer in Farnborough has absolutely no interest whatsoever in the aeronautics industry in Birmingham. Now, that could be an instance where that sort of exception to a restrictive covenant comes into play, because whilst you're working for a competitor, you're working for a competitor or being a competitor in a region where your former employer has no business interest whatsoever. So, I hope that's explained that one in a bit more detail, but bear in mind that it's the discretion of your employer whether they put that into your contract or your settlement agreement, or it might even be up to the courts to put that into your contract or your settlement agreement. Otherwise, if you're finding a settlement agreement hard, bring it to Richard.